What is Georgia's Advance Directive for Healthcare, and what role does it play in your estate plan? Hi, I'm estate planning and probate attorney Zach Beck with Peach State Wills and Trust, a division of the Beck Law Firm LLC here in Lawrenceville, Georgia, and we'll answer that question in today's video. So, what is Georgia's Advance Directive for Healthcare? Well, the Advance Directive for Healthcare is a form introduced by the legislature in 2007 that combined what used to be two forms, what was the living will and what was a healthcare power of attorney. The healthcare power of attorney allowed you to designate people you trusted to manage and make healthcare decisions for you if you were incapacitated. The living will, on the other hand, allowed you to make choices as to how you might want to be treated in a couple common end-of-life scenarios and provide guidance for what you'd want your healthcare agents and your physicians to do. The Advance Directive for Healthcare combined those two into a single form. So now, the Advance Directive for Healthcare allows you to designate people you trust to make healthcare decisions for you if you can't. You can choose to give these people certain powers, like the power to authorize an autopsy after your passing, the power to donate your body to medical study, or the power to donate your organs. And, like the living will, the Advance Directive for Healthcare allows you to designate treatment preferences for a couple common end-of-life scenarios. Now, this form doesn't allow you to designate preferences for any possible condition that you might be in. That form would be far too long for you to want to execute and for doctors and healthcare agents to understand. So instead, it provides guidance for two common scenarios. The first is an incurable, irreversible, terminal condition that will result in your death in a short amount of time. Think some condition that gives you approximately 3 months or less to live, some aggressive cancer, some aggressive degenerative disease. The second condition that you can choose to provide a preference for is a permanent vegetative coma. For either or both of those conditions, you can pick between 3 different treatment preferences. Option A, to paraphrase, is do everything you can to extend my life for as long as possible, even if you can't cure me. I want everything medical science has got, all the machines, all the procedures. If it can extend my life, I want it. Option B is its opposite. Option B is let me go, but keep me comfortable. I don't want all the machines, all the procedures, everything if it can't cure me, but I do want pain medicine and enough fluids and nutrition to not be in pain as I pass on. Option C could be somewhere in the middle. C is kind of an a la carte menu. You can pick and choose different types of treatments and machines and preferences that you'd want to have. So you could say, I do want CPR, but I don't want a ventilator. Or I do want a ventilator, but I don't want to be hooked up to feeding tubes and fluid tubes. It's important to note here that these preferences, option A, option B, or option C, only apply to those conditions that you selected previously. So either the incurable, irreversible terminal condition, the permanent vegetative coma, or both. And ADH is not a DNR, and these preferences don't apply, say, when you roll into the hospital after a cardiac event, but the doctors think you'll make a full recovery. They only apply to those conditions that you've selected, and only when multiple doctors, or at least one doctor, concurs that this is the condition that you have and that there's nothing that they can do. For more information about estate planning in Georgia, check out our YouTube channel, visit us online at peachstatewills.com, or call us at 678-344-5342.